Good afternoon, everyone. This is Tripp VanderWal. Welcome to Miller Johnson's new Benefits Lunch Break webinar series. Our intent is to host these webinars on the third Wednesday of every month. And really our goal here is to have these be a little bit more informal updates that we hope are beneficial to you. So on certain webinars, we may have me hosting with some other joiners, and it may be more like you listening into a discussion. Other webinars like today may be a little bit more substantive. And if we're lacking in topics, it may be allowing you guys to listen into ideas that maybe our group is somewhat kicking around and things that we're paying attention to. So, for example, we're noticing increases in litigation related to COBRA notice failures and retirement fee litigation. So we may not have a substantive series on that. We may be allowing you to listen in to kind of our group's discussions about what we see with those trends. So as you can see, our next webinar series is scheduled for Wednesday, November 18, and my partner Jeff Gray will be joining me, and he'll largely be talking about legal updates with retirement plans. Let me add one other thing before we get started here, or two other things I should say. Is after this, you will be asked to complete or have the opportunity to complete a survey. And in that survey, you can suggest future topics for this webinar. And I really encourage you to do so because like I said, we're going to try to do these, at least once a month. And we want to make sure that we're talking about things that are relevant to you. So if you take some time afterwards and fill out those surveys and let us know what you want to hear us talk about, we're happy to accommodate to the extent we're able. The one other item I want to talk, just quick mention, is we are going to try to take some question and answers in the question and answer chat feature. I'll try to answer those at the end, but I'm going to try to keep these webinars, since they are informal, to about 30 minutes so that you folks can listen, hopefully while you're enjoying lunch, and after 30 minutes, then you can get back to what I know is a busy day. So with that said, here we go on our first webinar, and it is a substantive update coming to what we call home theaters near you. And this is wellness programs in the ADA, part 2. So as we'll talk about, we've already seen part 1, and now here upcoming from the EEOC, we may see part 2 here in the future. So a little bit of background. The Americans with Disabilities Act generally prohibits an employer from doing two things. One is making a disability-related inquiry of employees, and two, requiring a medical examination of employees. The question is what is a disability-related inquiry, excuse me, and it really is a question or a series of questions that is likely to elicit information about a disability. That is the definition of a disability-related inquiry under the ADA. A medical examination, a little bit more complicated than that. It's a procedure, a test that is determined using the following factors. Is it administered or interpreted by a healthcare professional? Is it designed to reveal an impairment of physical or mental health? Does it measure the performance of a task or physiological responses to the performance of a task? Is it normally given in a medical setting? And does it use medical assistance? So the more of those factors we hit, the more likely the examination is considered to be a medical examination under the ADA. Why is that important? That's because a health risk assessment is a disability-related inquiry under the ADA to the extent that questions on that health risk assessment are likely to elicit information about an individual's disability. Further, a biometric screening is a medical examination under the ADA. So without an exception, the ADA would generally prohibit an employer from implementing any type of wellness program that utilizes either a health risk assessment or a biometric screening. And of course, as many of you probably know on the line, that we do have some exceptions that do allow employers to do this under the ADA. And keep in mind that we're going to talk about two exceptions that are relevant to wellness programs. There are maybe other exceptions, such as fitness for duty, but we're not going to cover those types of exceptions under the ADA in this webinar. So the first one is the exception I think most people on the line are familiar with, and that is the voluntary exception. And the ADA permits employers to conduct voluntary medical examinations and make voluntary disability-related inquiries as part of an employee welfare health program. The question here is, though, is a lot of employers, in order to encourage participation in a voluntary either HRA or voluntary biometric screen, will offer either some incentives, or on the other side of the coin will impose some type of penalties for non-participation. And the big question is when do these incentives become so significant or significant enough that truly the wellness program is not quote unquote voluntary? And as we'll talk about, we had some regulations that were issued in 2016 that seemed to resolve that uncertainty, but because of some subsequent litigation, we were forced back into that world where we don't really know the answer to that question, and of course, reasonable minds can disagree. The less common exception, at least until new regulations are issued, is what's called the bona fide plan safe harbor exception. And the ADA does not prohibit or restrict an employer from establishing, sponsoring, observing, or administering a bona fide benefit plan that is, quote, is based on underwriting or classifying risks, administering such risks, as long as that plan is not inconsistent with state law. And so there have been several employers that have implemented wellness programs that may have fallen outside of what we typically think of a voluntary wellness program, and argued that it's still not a violation of the ADA because it's a bona fide plan. The EEOC has long held a position that this safe harbor does not apply to wellness programs, but at least in two significant lawsuits, courts have disagreed with the EEOC's position and have determined that wellness programs can be permissible, i.e. not violate the ADA under the bona fide plan exception. So before we talk about part two, or what we expect the EEOC here to issue at some point in the future, let's talk about the voluntary exception, part one, if you will, under the 2016 regulations. For those of you that are familiar with voluntary-based wellness programs, you are aware that in 2016, the EEOC issued regulations on what requirements a wellness program must comply with in order to be quote-unquote voluntary. And I don't want to spend a ton of time on these today because I think most people are familiar with these regulations, but let's just quick run through these. The wellness program must be designed to promote health or prevent disease. It can't require employees to participate, and that is probably somewhat obvious. In order to be voluntary, it can't require employees to participate. The maximum incentive, or I guess absence of a surcharge or penalty, cannot exceed 30% of the total cost of employee-only coverage. It cannot deny coverage under any of its group health plans or benefit packages for non-participation. This was a big one for some employers that may have identical benefit packages, but one may have higher deductibles. And if you satisfied the wellness program criteria, you were eligible for the benefit packages with lower deductibles. And if you didn't satisfy that wellness program criteria, you were automatically kicked into the one with higher deductibles. Those designs became problematic under the 2016 regulations. And finally, the last two, it does not take any, the employer does not take any adverse action against employees for not participating in the wellness program. And then we had a template notice that employers were required to give out to participants that really addressed, the use and protection of any medical information that the employer would obtain as a part of the wellness program. Again, so those regulations, while they were frustrating in some regards because they tried to mimic the wellness program rules that applied under HIPAA in the ACA, they weren't exact. So we had to really look at whether a wellness program was first subject to HIPAA and the ACA and impose those rules, and then if it was also subject to the ADA or GINA, then we'd have to look at those rules. And while they largely aligned, they weren't perfectly symmetrical, if you will. Having said that, in 2017, the AARP filed a lawsuit against the EEOC and basically claimed that its conclusion that a 30% limit on incentives was not a reasonable interpretation of the term voluntary under the ADA. And it really said, it relied on this law called the Administrative Procedures Act that said, your decision of this 30% was arbitrary and capricious, and therefore it should be thrown out. The federal court agreed with that, gave the EEOC some time to issue some new regulations to support its justification that a 30% limit was still voluntary. Because of all of the hoops that the EEOC has to jump through to issue regulations, it was not able to issue regulations within the court's predetermined schedule. And ultimately what happened is the court vacated that 30% limit, and then the EEOC issued new regulations that effective January 1, 2019, it reissued new regulations, again, the same as the 2016, but removed that 30% limit. So naturally, the $1 million or $300,000, if you get what I did there, question became, what amount of incentive is permissible and that allows a wellness program to still be voluntary? Is it nominal? Can I give employees T-shirts and keychains and water bottles to participate in a wellness program? Can I still use the 30% limit even though it's not in the regulations? Some more aggressive employers may have said, hey, that 30% was a cap. It's not in there anymore. I can go a lot higher than 30%. I will tell you that this is still there's a lot of uncertainty around there. I think if you would have stayed with the 30%, you were unlikely to see any EEOC enforcement action. But that doesn't mean that participants couldn't have filed a lawsuit, for ADA violations against you themselves. So I would say the more conservative approach was that employers took was either, reducing it to nominal incentives or staying at 30%. Some of those employers with higher risk tolerances may have said, hey, I'm going to increase it past 30%. All right, with that history, that brings us to part 2, the bona fide plan safe harbor regulations, which are coming in the future, again, to a home theater near you. So on June 11, 2020, the EEOC held a meeting to discuss new proposed rulemaking on wellness programs. And if you are interested in this, you can find the transcript to this meeting using Google. That's, I think, how I found it. And read the transcript of this meeting. It's only about 15 to 16 pages, I believe, and really is the basis of this first webinar. So in this meeting, the EEOC approved on a 2-to-1 basis, there's only currently 3 commissioners on the EEOC, the issuance of new wellness program regulations. And just to give you a kind of a highlight of what that means, where we are in the progress of when we're going to see these proposed regulations. Once they approve those regulations, they were sent over to the Office of Management and Budget, and then the Office of Information and Regulatory Agency, I think is what OIRA stands for. Those 2 agencies will review those regulations and will return them to the EEOC, likely with comments. When the EEOC gets those back, they'll review the comments from these other organizations or these other agencies, and may make further revisions before they're issued and released to the public. So again, this happened in June 11 in 2020. I don't anticipate that we will necessarily see proposed regulations yet this year. But if history has anything to tell us, these federal agencies love to issue regulations around holidays. So to the extent that we may see something this year, I would look for maybe right before Thanksgiving or right before the Christmas New Year's holiday. Other than that, if I had to bet, I would probably bet that they'll be issued sometime in 2021. And so what do these regulations do? Well, they clarify the rules for voluntary wellness programs. So these regulations clarify the rules that apply to participatory and health contingent wellness programs that are not offered as part of a health plan. It's not entirely clear what offered as a part of a health plan means without actually being able to review the regulations. I anticipate that, for example, if your if the incentive or whatnot of your wellness program either includes some type of medical care, so like a biometric screening, or is tied to reductions or increases in your group health plan's premiums, that is probably considered to be a wellness program that is offered as a part of the health plan. But again, that's some uncertainty that we're going to need the proposed regulations to resolve. Again, you can't require employees to participate. I think that's relatively obvious. The third one is, maybe I should have bolded on here, is may offer no more than de minimis incentives to encourage participation. So this is a fundamental shift in voluntary wellness programs. If you have voluntary wellness programs that are not offered as a part of your health plan, and you offer anything more than the keychains, t-shirts, water bottles, it looks like those are not going to be permissible under the ADA. And I can almost hear from my office on a webinar the collective sigh of, what does that mean? And before you get too worked up, just wait. We'll talk about we'll talk about how we still can have wellness programs under the ADA that offer incentives, but it may not be a voluntary wellness program. Fourth, you still can't deny coverage under any group health plan or health package. And fifth, you can't take any adverse employment action against employees for non-participation or failing to achieve certain outcomes. So again, I think the biggest change here is the fact that basically voluntary wellness programs, any incentive or penalty, if you will, can't be more than de minimis or nominal, if you will. Bona fide wellness program. So the regulations also focus on this bona fide wellness plan exception. And this is going to apply to health contingent wellness programs that are offered as part of the health plan, and require employees to satisfy a standard related to a health factor to receive a reward or avoid a penalty. And again, it's my interpretation that the bona fide wellness program exception does not apply to only participatory wellness programs, because those participatory wellness programs, arguably can't be used to underwrite or classify risk, because you're just asking someone to participate rather than using the information you're gathering from that wellness program to underwrite or classify risks. But that could change. My interpretation at this point is that these bona fide wellness plans, wellness exceptions, only going to apply to health contingent wellness programs, and again, that are offered as part of the health plan. It's unclear what that means, so I'll be anxious. But again, if you have, for example, a biometric screen or an HRA where people have to hit certain measurements, and of course under HIPAA we have to have reasonable alternative standards, and they receive a reward or a penalty, those are the wellness program, and the penalty is tied to maybe a reduction or increase in premiums to the health plan. I anticipate that would be a health contingent program that is offered as part of the health plan. Here, the incentive must be limited to the total cost to 30% of the total cost of coverage of the plan in which the employee is enrolled. That's a big change. So under the previous regulations for voluntary wellness programs, it was 30% of the employee only coverage tier. This, like the HIPAA rules, is now 30% of the total cost of coverage of the plan in which the employee is enrolled. To be a bona fide wellness program under the ADA, you must also comply with all the HIPAA wellness program rules. You must use any aggregate data collected to classify and administer employee risk. Again, I think that's the requirement that is necessary to satisfy the underwriting or classifying risk. And it'll be interesting to see what exactly, if that means, and how strictly that's enforced, or what strict requirements are a part of that under the proposed regs. A few other issues is must comply with the rules applicable to voluntary wellness programs. So again, you can't require employees to participate. You can't deny coverage under any of your group health plans or health packages. And again, you can't take any adverse employment action. So I think those are relatively similar to not only the voluntary wellness programs, but the rules we operate in today's world. Finally, some of the other rules is there's going to be strong, quote unquote, strong confidentiality protections with respect to any medical information that is collected as part of the wellness program. And this includes a requirement that the employer sponsor of the wellness program must ask, quote unquote, reasonable questions up front to become familiar with the third-party security policies. So if you are outsourcing the administration of your wellness program to a third party, you have to ask questions up front so that you become aware of their security policies. I'm interested to see what this means. This was actually a requirement that was added as an amendment proposed by one of the EEOC commissioners that was adopted by the other two. It did specify that the employer doesn't need to get any types of guarantees with respect to the third-party security policies, but they need to ask questions so that they're familiar with them. Second, employees' medical information may only be provided to an employer in aggregate terms that do not disclose or are not reasonably likely to disclose the identity of a specific individual. And then the last one may go without saying, but employers may not require employees to agree to the sale, exchange, sharing, transfer, or other disclosures of medical information that's collected as a part of the wellness program. And while the transcript didn't talk specifically about a notice requirement, I would be shocked if we didn't have some type of notice requirement that was part of these proposed rules in the past. So in conclusion, I would say that my interpretation, again, by these transcript is that participatory wellness programs are no longer or will no longer be able to provide any incentives other than de minimis incentives to encourage participation. And let me just, again, before, if I've got any folks that are worried out there in the audience, I don't think you can get employers that have participatory wellness programs with incentives that are more than de minimis have to quick run out and get rid of all those incentives or surcharges at this point. I think that's something that you should think about that you may have to do in the future when these regulations are issued, but I think you're largely okay until we see these proposed regulations or actually probably even until these regulations are finalized. But again, it is my opinion that in the future, participatory wellness programs will no longer be able to provide anything more than a de minimis incentive. Health contingent wellness programs appear to be permissible under the ADA's bona fide plan safe harbor, as long as generally it complies with the HIPAA wellness program rules. Again, there's some other tidbits in there that we have to make sure these rules that these comply with the ADA, but I think largely, as long as they comply with HIPAA, we're going to be good to go. And that should probably be some relief to those of you on the phone, is that if we design something that's going to be permissible under the ADA, or I'm sorry, under HIPAA, it's probably going to be permissible under the ADA, again, to the extent it's health contingent. But again, I have this in bold again, just to reiterate, even though I've already mentioned this, is that these rules could easily be changed several times before they're finalized. They could be changed by OMB. They could be changed by the EEOC. EEOC may submit them to the DOL and IRS to ask for their input and maybe change based on those comments. So again, this is all prediction. I don't think any of the information you're gathering from this webinar requires immediate changes, but maybe things to write on your longer term planning agenda items to consider in the future. And obviously, when these regulations are proposed and finalized, we will have webinars and do client alerts on that and be able to have much more concrete guidance on what is and what is not allowable. And with that, I will see if we have any questions in the Q&A. I'm not seeing any questions. We did actually finish a few minutes before 12:30. So I will sit around here for a couple minutes and wait to see if we had any questions. Again, you can put questions or ask questions through the question and answer chat box feature. And I will read those back and answer them here live. First question is, are we okay in 2020 if we're in the 30% for a bona fide plan? Again, I would say yes. So since these regulations are not even released yet, I would say generally you're probably okay. But keep in mind that the 2016 regulations, vacated that 30% limit. So again, we're kind of in no man's land where we don't know where a plan is voluntary versus where a plan becomes involuntary because the incentive is so high. I think 30% is probably a conservative approach. I don't think the EEOC is going to come after you. Clearly, in their old regulations and in their new regulations, they think 30% is reasonable. But again, it is possible that a participant could bring some type of ADA violation lawsuit, even on a 30%. But I think that would be unlikely. Another question is, having an HRA and biometrics are still as long as they are voluntary. Again, I want to focus is that I don't think you have to make any changes right now. So if you have these, yes, they're probably all still okay, but let's fast forward. Can we have an HRA and biometric screening after these regulations are issued, if they're issued in the form that I anticipate? And I think, yes, having an HRA and biometric screening is still okay. Now, if it's just going to be asking employees to take the HRA or to go do the biometric screening, and I'm not going to give them any type of incentive or reward, that's a participatory wellness program. And really, I can't give them anything more than some de minimis prize for taking the HRA or doing the biometric screen. Now, if I actually want to create an incentive, it appears that I actually have to put metrics in the HRA. So, for example, my BMI or my cholesterol have to meet certain levels, or biometric screening, maybe my glucose has to be a certain level in order to get that incentive. And of course, I would have to have a reasonable alternative standard under HIPAA. But it looks like the participatory, you just take this HRA, you just take this biometric screen, in order for it to be voluntary, you can't really have anything but a very small incentive. Again, this is in the future. This is not anything that I would be making changes for today or even for 2021, unless we hear otherwise before that. All right, those were the only two questions. I hope all of you enjoyed, and this was a beneficial seminar for you. We hope to have you back here in November, again, when my partner Jeff Gray will join me and talk about retirement plan questions. And please take a few minutes to fill out the survey. Let us know your comments, and really, please let us know any future topics you would like us to discuss. Have a great afternoon, everyone. Thanks.